Hello, everyone. Thank you for coming. As Kyle said, I am Madison McCormick. I am from Western New York, and hopefully in the future, I'll be attending a master's program in public history. When I was at Marietta, I was fortunate enough to volunteer at the castle and work in the college's special collections. The separation of Henry and Sarah Dawes, marital discord in early Ohio. There has never been a cause here which excited so much interest, and there never was a judgment which, in this place, more heartily meets the response of amen on every side than does this. William Bascom wrote on November 13th, 1841. Bascom, a lawyer for Sarah Dawes, was writing about the outcomes of the two separate Dawes separation cases that plagued Morgan County, Ohio in 1841. The Henry and Sarah Dawes separation illuminates the agency that accompanied personal status and wealth in mid-19th century Ohio divorce cases. The Dawes case also demonstrates the prevalence of issues of societal pressure opposing divorce, the centrality of child custody, and the importance of alimony in such cases. Divorce occurred in the United States as early as 1629 when the Massachusetts Bay Colony created a judicial tribunal that had authority over divorce matters. Each colony had its own history of divorce depending on who ruled it at what time. For example, under Dutch rule, divorce in New York was infrequent, but it did occur. When England controlled New York for 112 years, only 4 divorces occurred. By 1799, divorce was allowed in 12 states and the Northwest Territory. The first marriage in the Northwest Territory occurred on February 6, 1789, between Winthrop Sargent and Rowena Tupper. Sargent, 36 at the time of his marriage, was Secretary of the Northwest Territory, a very prominent position. Tupper, 13 years his junior, was a member of the prominent Tupper family in Marietta. Tragically, Rowena Sargent died less than a year into marriage from complications of childbirth. The child died as well. If Rowena Sargent had not died so soon into the marriage, the Sargent marriage might have been the first candidate for divorce in the territory. Winthrop Sargent's own brother-in-law described him as a consummate tyrant and rascal. Nobody loved him. Soon after their marriage, Sargent put on his true caricature. He became very imperious and hot and broke off all civil and social intercourse with the family. Local historians have traditionally attributed the first divorce in the Northwest Territory to Lucy and John Gilbert Pettit in 1800. However, there are records of 2 divorces in 1796. According to the March 26, 1796 edition of the Centennial of the Northwestern Territory, which you see on your screen, the court has decreed divorces from the bands of matrimony between George Morefoot and Catherine his wife, William Lemond and Martha his wife. Not much is known about these 2 couples, which is perhaps why their divorces are not often recognized by local historians. The Pettit divorce is relatively well known in the area, partially due to the pedigree of the people involved. Lucy Pettit came from the prominent Woodbridge family in Marietta. Writing to a family friend, Lucy Pettit's brother Dudley exclaimed, "Lucy is at last separated from that villain Pettit." On December 8, 1800, the Northwest Territorial Legislature decreed the Pettit divorce. Even though the Pettit divorce was not the first in the territory, it potentially was the first divorce petitioned by a woman. Marriage laws existed for the territory as early as 1787, showing up in the Northwest Ordinance. However, the first divorce statutes did not appear until 1795, a year before the first known divorce. The first divorce laws were adopted from the Massachusetts statutes of 1795. For a marriage to be terminated in 1795, one party in the marriage had to commit bigamy or adultery or be impotent. A divorce from bed and board, otherwise known as a legal separation, was allowed for extreme cruelty. On January 20th, 1829, Sarah Cutler, daughter of esteemed Ohio pioneer Ephraim Cutler, and Henry Dawes, a shopkeeper, married. Henry Dawes was born on May 4th, 1804 in Thomaston, Maine. Henry's father was William Mears Dawes, a prominent politician in Ohio, serving as a county representative in the legislature for a year, followed by 7 years as an associate judge of the Court of Common Pleas. Henry Dawes moved to Malta, Ohio with his family when he was 14. In Malta, Henry worked on the family farm and then in the family store, an occupation that would then become his career. Henry would have been quite an eligible bachelor at 25, as he was from a respectable family and had a good job. Henry's wife, Sarah, was 5 years his junior, having been born on April 4th, 1809. The Dawes wedding was only attended by family. Of the wedding, the bride's mother, writing to her son, expressed that, "Last evening at 5 o'clock, your Sarah became the wife of Mr. Henry Dawes. Tomorrow, Sarah leaves us for another home. Oh, what a thought, but she has every prospect of happiness." On the screen here, you can see the marriage record of Henry and Sarah Dawes. Henry Dawes never accused Sarah of being a bad wife. It can be assumed that she was a good wife to him. A man was theoretically supposed to know if a potential spouse would make a good wife if she possessed certain characteristics laid out in George W. Quimby's Marriage and the Duties of the Marriage Relations, published in 1852. This is just one book of many on this topic. A woman would make a good wife if she was a dutiful daughter, a kind and affectionate sister, had a desire to be useful, had good economic habits, was familiar with domestic duties, and was neat. Quimby also described a good husband. A man would make a good husband if he was a dutiful son and a kind brother and also had good economic habits. Other indicators of a good husband were if he was a good friend, was honest, and did not drink. Unfortunately, nothing is known of the Dawes' personal life prior to marriage, so it is unclear if they had the traits indicative of a good spouse. When the Dawes married, Sarah's mother wrote to her brother, but she has every prospect of happiness. Mrs. Cutler must have thought Henry would be a good husband to her daughter. At the very least, there was no warning signs he would be a bad husband. Divorce was well established in Ohio by the time of the Dawes' marriage. Carol Wilsey Bell's book, Ohio Divorces, The Early Years, has a list of divorce cases in Ohio from 1790 to the 1880s. The entries in the book were typed into an Excel spreadsheet, which was then analyzed using statistical software. Using statistical analysis, divorce results in early Ohio can be quantified. By 1829, over 150 couples had successfully divorced in Ohio. During the first half of the 19th century, the main reasons given for a divorce were adultery, cruelty, drunkenness, and bigamy. By 1850, the grounds for divorce had increased threefold. In addition to adultery, bigamy, and impotence, couples could now divorce for cruelty, an absent spouse, fraudulent contract, gross neglect of duty, habitual drunkenness, and imprisonment. The average marginal effects column shows how likely each reason affects the likelihood of having a divorce granted. The asterisks next to the number shows the significance, with one asterisk corresponding to a 90% certainty, 2 to 95%, and 3 with 99%. In Ohio, from 1790 to 1850, if the cause on the divorce petition was adultery, the likelihood of success increased by 23%. Drunkenness had a lower success rate and bigamy even lower. Cruelty increased one's chances of success by about 5%. If there were more than 2 causes on a divorce petition, say adultery and habitual drunkenness, the chances of success dropped by almost 40% compared to if just one cause had been listed. Having one cause listed on a divorce petition, no matter the cause, was always more likely to lead to a divorce than having two causes. Ohio would not grant a divorce for a cause not listed in the divorce statute. This became evident in the Hewlings v. Hewlings case from 1844, where this unofficial rule was given official standing. In this case, a man wanted to divorce his wife because she was not chaste when they married. The court ruled that because he knew of her impropriety before marriage, there was no fraud. The case rested on a cause not listed in the Ohio statutes and was therefore dismissed. A wife filing for divorce was 20% more likely to have her divorce petition granted than that of her husband. Some years had significantly lower success rates for divorce petitions. The string of years between 1836 to 1839 saw a decrease in the likelihood of petition success, everything else remaining constant. The population size of a county also had an effect on petition success. For example, if a county increases its population by 1%, the likelihood of divorce petition success decreases by 15%. This could be due to the fact that in a smaller county, a spouse's transgressions were more likely known. The majority of the cases were in larger counties. Franklin County, where Columbus is, represents 15% of the data and had a population of 25,000 in 1840. Knox County is 10% with a population of 30,000 that same year. Another interesting thing of note is that if a spouse filed for divorce citing their own fault, the divorce was 16% more likely to be granted than if someone filed citing their spouse's transgressions. A spouse would have admitted in return for different alimony and custody arrangements. A husband might have admitted he was cruel, so he would not have to pay alimony to his wife, or a wife would have admitted that she had an affair to keep custody of her children. Through the course of their marriage, it became clear that Sarah Dawes would not make the best of a bad bargain. When Henry and Sarah Dawes split, they sought a legal custody and alimony arrangement as opposed to an actual divorce. The couple's family connections helped make this possible, so they were not stuck in a bad marriage, nor did they have to go through a gruelingly public divorce trial. After Sarah refused to return to live with her husband, she stayed with her father in Washington County in the old stone house, whereas Henry resided in Morgan County. Had Henry sought divorce from his wife, a notice would have been placed in the local newspaper for 6 weeks announcing the upcoming divorce hearing. Henry Dawes did not want his separation from his wife known. Writing to his father 2 days after his wife refused to return to live with him, Henry explained how he could not get his sister to do his housekeeping because it would make public this affair. I cannot bear to have it known yet, or until some official and legal adjournment is made. Henry clearly did not get what he wanted because their separation became quite known in the town, though was never discussed in any official capacity. Barely a week after Sarah Dawes refused to return to Malta with her husband, a Cutler family friend, Catherine Barker, wrote to her sister, Sophia Barker Browning. My sympathy and feeling for Sarah Dawes are inexpressible. I never felt as much for any one individual as I have for her these many years, though I actually knew little. I often felt that her sufferings were extreme. We felt to wish Mr. Dawes no evil, but hope if there is mercy for him, he may find it. He has taken a very singular course in regard to this affair, which makes him appear much more ridiculous than he otherwise would. He tries to appear very cheerful indeed, and when the subject is mentioned to him of his wife's leaving him, he denies the whole, says she is going to return when he gets his new house completed, threatens to prosecute those that are telling such lies about him. The name of Sister Dawes is dear to many in Malta. Oh, that grace may be equal to her day in trial. She has not left any enemies behind, excepting the one that should be her best friend. The public mind is entirely in favor of Mr. Dawes. and so against him in some instances that they would be glad to see him mob. This letter shows the strong public support for Sarah and conversely, condemnation for Henry. Perhaps Henry's concern over having the separation be public was because he knew people would be against him. His business could have suffered as a result of the general public's ill will towards him. Barker's words were likely in response to a letter dated 8 days earlier, in which Sophia Barker Browning lamented, "Mrs. Dawes is in deep trouble. Her husband is expected down to Warren soon and will no doubt try to take her children. She says she cannot live with him and cannot part with her young children. He was then determined to have every child. He then said he must have Henry, the oldest son, and they might keep the rest till spring, hoping, as they suppose, she would forgive him in time, but she will not go back. Now she fears he will take Henry a great way off, and she will not see him for years perhaps. She walks the room and weeps and groans and prays." Henry and Sarah Dawes did not have a happy marriage. The court documents relating to the separation reveal just how bad their marriage truly was. As early as 5 years after they married, the conduct and deportment of her said husband towards this respondent became and was unkind, unsocial, cruel, and even at times brutal. On one occasion, Sarah was pregnant, and the harsh and cruel conduct of her said husband towards her was such as to occasion premature delivery and abortion. Henry even admitted his viciousness to his father-in-law. When questioned about his cruelty, Henry said he had been severe, necessarily so. He meant to be the master of his own house. Several other people besides his wife and her family reported his cruel treatment of her. Mary Forgrave lived with the Dawes for 4 months in 1837. When asked about Henry's conduct towards his wife, Forgrave recounted, he appeared very grim and cross and very often not answering when she spoke to him. She would very often come out of the room crying. His wife was sadly not the only target of his cruelty. On one occasion, Henry beat one of his daughters so badly that her clothes could not be fastened for several days. Henry Dawes was a cruel man, and it is no wonder Sarah did not want to return to live with her husband, to subject herself and her children to any more of his violence. Separation is much less visible than divorce. With this logic, many people thought a married couple's happiness was less important than maintaining social stability. In some cases, though, such as in New York, a legal separation provided more favorable financial outcomes than an actual divorce did. While wives could get alimony after a divorce, they were entitled to nothing besides that. For example, if a man died but he had been legally divorced, his former wife was entitled to nothing. If they had only been separated, the wife could get some of his estate. When Henry Dawes died, Sarah received money since he did not leave a will. Being his widow, Sarah would have been entitled to 1/3 of his estate, but she waived her right of dower to receive an equal share with her children. If the Dawes had divorced, Sarah would have received nothing upon Henry's death. If the wife sought legal separation, she would be trading her ability to remarry for potential financial benefits. Perhaps having a bad husband made some women not want to remarry at all, so they were content with simply a legal separation. Some couples had no choice but legal separation. In the Ohio statutes of 1795, if a spouse was cruel, the only action to take was a divorce from bed and board. If the Dawes were married and facing marital discord 45 years prior to their separation, they would not even have the option for a full divorce. It is unknown what prompted Henry Dawes to seek legal action almost a year and a half after he and his wife separated. Ephraim Cutler and William Dawes were both former judges who were well acquainted with the law. they would have informed Sarah and Henry of the best course of action to take in seeking a separation. Ephraim and William knew how to accomplish what their children wanted without having the horrors of an extremely public trial. Sarah and Henry were lucky in that their status and family background allowed them to become legally separated and avoid the ramifications of widespread public scorn. Many couples of lower classes were probably not even aware that they could separate without having an actual divorce. And even if they were, they likely could not have afforded it. Instead of having to prove why their marriage bond should be severed, the Dawes had to prove why the other should not have custody of their children, and for Sarah, why she deserved alimony. And in a typical divorce case, the issue of custody and alimony would be included within the trial. Henry and Sarah's legal battle was more difficult and costlier than if they simply saw a divorce. Upon the conclusion of the case, Sarah's lawyer wrote to her father that Henry can have no plea that he has not had a fair trial. He has had 3 of the ablest lawyers in Ohio and every indulgence from the court, which has not been extended to us. Henry was a man of means and high status, which allowed him to have the top lawyers and leeway from the court. Even though Sarah was from the same means and status, she was not given the same freedoms from the court because she was a woman. A woman of lower status, especially with little money, would not have been able to achieve what Sarah did in winning the 2 trials. Divorce law came a long way between 1795 and 1839 when the Dawes ceased living together. By 1840, a divorce could be granted for bigamy, willful absence, adultery, impotence, extreme cruelty, fraudulent contract, gross neglect of duty, and habitual drunkenness. Sarah Cutler could have attempted to divorce her husband, citing cruelty if she wished. Conversely, Henry Dawes could have attempted to divorce his wife for adultery. On at least one occasion, Dawes did accuse his wife of adultery to her face, as recounted in a witness deposition. The adultery accusation appears to be a fabrication, however. There is no evidence that Sarah ever cheated on Henry, and if there were, it would have most definitely been brought up in his complaint to obtain his children. Dawes could not have accused his wife of willful absence, however. At that time, a spouse needed to be gone for 3 years to file a willful absence claim. The Dawes separation consisted of 2 separate but concurrent cases: Henry Dawes versus Sarah Cutler Dawes and Ephraim Cutler, in which Henry Dawes sought custody of their children, and Sarah C. Dawes versus Henry Dawes, in which Sarah Dawes sought alimony from her husband. Henry Dawes, through his lawyer, filed a complaint with the court on March 8, 1841, in which it was stated that the couple's 4 children were wrongfully detained from his custody in contact by Ephraim Cutler of the said Washington County, and Sarah Dawes, the wife of your petitioner, who now resides with the said Cutler, and your petitioner is unable to obtain the custody or contact of his said children or either of them without the aid of legal process. The Dawes had 6 children: Lucretia, Henry, Lucy, Jane, Rufus, and Ephraim. Up until this point, Henry Dawes had just taken their older son, also named Henry, and left the other children alone. It is worth noting that this petition made no mention of little Ephraim, as he was less than a year old at this point, having been born at the Cutler's house. Henry's father-in-law thought that it was his intention to entirely separate from and abandon his wife, and that he brought her and her children to the Cutler house to that purpose and end. According to Cutler, he and Henry had even talked about separation before, and that if that had happened, the children would stay with their mother. Henry's language suggested his children were being held against their will, and he could not get to them. Ephraim Cutler's response clearly indicated that Henry had not tried to make any arrangement for his children, save taking the eldest boy away. Perhaps Henry was trying to assert his authority over his wife and children by taking court action out of the blue because he simply could. Sarah Dawes believed her husband purposely abused her so she would be forced to return to her father's house. Perhaps Henry just wanted to be rid of his children and did not initially think of how that would affect the arrangements of their children. In most divorce cases, the issue of custody was important. However, in the Dawes separation, it was paramount because it was the essence of the whole suit. Unlike the original divorce statute in 1795, the 1840 statute is silent on the issue of custody. Since there was no divorce petition filed and therefore not a presumed innocent party, it is unclear if the statistics would have worked in Henry Dawes' favor. From 1795 to 1850 in Ohio, if the wife filed for divorce, her husband was approximately 37% less likely to receive custody of their children. This leads to the concurrent case and a potential reason why Sarah Dawes could have filed for alimony. Sarah Dawes submitted her bill for alimony on June 29, 1841, almost 4 months after Henry had asked for custody of the children. Sarah requested money to provide for her and her young children if they were to stay in her care. Unlike custody, the 1840 divorce statute was not silent on matters of alimony. Like the original 1795 statute, if a divorce was the fault of the husband, the wife was restored to the property she brought to the marriage and was entitled to alimony as the court saw fit. Unlike the previous statute, the 1840 code made no distinction between having living children or not. If the wife was at fault, she could not get her dower back as she potentially could have if it was her husband's fault. The wife could get her property back and a share of her husband's money or property as the court saw fit. As the Dawes case was not a matter of actual divorce, it is unclear what alimony laws applied to this case. It is probable that Sarah Dawes petitioned for alimony to strengthen her claims for custody of her children, as at this time alimony was indistinguishable in these cases from child support. The Cutler family was wealthy, and as Ephraim Cutler stated in his answer to Henry Dawes' petition for custody, Henry left his wife and children at the Cutler house because he knew they would be well cared for there. Sarah Dawes was fortunate in the fact that she came from a background where if she lost the alimony case but won the custody case, she would not have to worry financially. Other women needed to be granted alimony along with their divorce because without it, they might not have survived. The lack of financial stability after a divorce was a deterrent towards divorce and separation. As a divorce case was tied with alimony and custody, the wife's chances of getting alimony if the divorce was granted was rather high. Cases that hinged entirely on alimony and custody did not have that kind of insurance. Sarah was in a position where she did not need to consider the consequences of her petition for alimony failing. Unlike other women, Sarah Dawes did not need her husband's money. If Sarah Dawes' petition for alimony was simply a ploy to strengthen her custody case, it worked to some extent. Sarah Dawes maintained custody of her daughters until they married and of her sons until they were 10. Even though custody was clearly delineated, each parent was to have access to the children at all suitable times. As for alimony, Dawes paid his wife $300 once and $200 every 6 months. The resolution of the two cases was not atypical for the period. In a case from 1837 in Cuyahoga County, the wife retained custody of her son until he was 14, at which time he would go to his father. In an 1840 case from Sandusky County, the wife retained custody of her youngest son until her husband chose a guardian. The wife also got land, $300, 2 cows, and 14 sheep as alimony. In an 1848 case in Knox County, the husband got custody of the children, 3 young sons, and was given $1,400 towards their care and education. The 1848 case was filed by the husband for willful absence of his wife. In an 1843 case from Brown County, the wife got custody of the daughter while the husband got the son. This case was also caused by willful absence of the wife. An 1837 case from Greene County had the wife get custody and receive $33 every 3 months. These cases are just a small sample of the other cases in Ohio during the time period where alimony was given to a wife and the custody of all the children were not given to the same parent for their entire childhood. Even though her husband did not die until 16 years after their court cases, Sarah Dawes dressed as a widow for the rest of her life. By dressing as a widow, Sarah announced her status as a woman separated from her husband, not divorced. Even after the custody arrangements were settled in court and the case was known, Sarah tried to avoid the stigma of a divorced woman. Upon her husband's death in 1867, Sarah Dawes inherited some of his estate, though she waived her right of dower, so her share was equal with that of her children. Sarah Dawes died in 1896 at the age of 87, having outlived 3 of her 6 children. Even after she died, Sarah Dawes was not fully rid of her husband. As you can see in the picture here, her gravestone reads, Sarah Cutler Dawes, wife of Henry Dawes. The Dawes separation cases just barely missed perhaps the most significant change to happen in Ohio divorce law. The Court of Common Pleas transformation to try divorce matters in 1843. Changing jurisdiction to the Court of Common Pleas made divorce more accessible to the average person, thus increasing the number of divorces. Writing in 1853, Henry Folsom Page, in his book, A View of the Law Relative to the Subject of Divorce in Ohio, Indiana, and Michigan, said of the change, perhaps there is no statute in Ohio more abused than the statute concerning divorce and alimony. Perhaps there is no statute under which greater imposition is practiced upon the court and more injustice done to individuals. Throughout the book, it is evident Page was against divorce. However, it is no clearer than in that quote. Page viewed divorce as a burden to the courts. The move to the courts of common pleas was rebuked by opponents of divorce and embraced by those wanting out of a bad marriage. During this period, other significant changes occurred as well, with the court jurisdictions regarding legislative divorces and the state Supreme Court. A legislative divorce was where a divorce would be granted through the legislative body and would be recorded as an act of law. Legislative divorces were banned by the Ohio Constitution in 1851. The state Supreme Court could grant divorces in Ohio between 1804 and 1853. The Court of Common Pleas still retains the only right to grant divorces in the state of Ohio. Ohio Divorces, The Early Years by Carol Wilsey Bell gives context to the divorce environment in Ohio during the first half of the 19th century. Along with the quantified chances of divorce petition and custody success, other historical data can be gleaned from the book as well. Of the cases recorded in the book, 62% were through the state Supreme Court, 30% through the Court of Common Pleas, and 8% from the state legislature. Other information the book details when available is what year the couple was married, if a party remarried, and if a previous divorce petition had been filed. Unfortunately, there is not enough data to do analysis on that information. Some of the entries were quite interesting to read, while others were very sad. My favorite case in the book is an 1836 case from Stark County, where the wife was given land and the patent right for a labor-saving rotary gate that was given to her husband. Divorce in early Ohio consisted of public backlash and fights over custody and alimony. Instead of getting a divorce to terminate a tumultuous marriage, Henry and Sarah Dawes used the law to settle issues of custody and alimony. Henry and Sarah Dawes were not entirely confined by acceptable societal standards. They used aspects of the law to resolve their marital discord instead of making the most of a bad marriage. While not obtaining an actual divorce, the Dawes did do more than most couples in taking charge of their own lives. On the conclusion of both trials, Sarah Dawes' lawyer remarked, "Justice as at least sometimes done here on earth, though talents and learning and influence may be arrayed against it." Through their strategic use of the legal system, the Dawes proved they had agency in their own lives to achieve a better situation for themselves. The Dawes' specific situation, however, would not have been able to be achieved if it were not for their status. The court gave Henry and Sarah Dawes, along with hundreds of other couples in Ohio in the 19th century, the ability to sever marriage ties if desired in different ways, dependent upon status and wealth. Do we have any questions?
Thank you, Madison. Yes, we do have some questions coming in. Judy asks, although your presentation was on marriage divorce, I am curious about marriage laws. At what ages were men and women allowed to marry? If very young, was permission needed from one or both parents? Do you happen to know that?
That is a very good question. I do not know that. I was looking specifically for divorce laws and not marriage, so I didn't really get into that. But the marriage laws would have changed throughout the years, as did the divorce laws.
Great, thank you. We have one more question from Judy that I'll ask in just a second. I just will remind everyone to go ahead and enter their questions into the Q&A feature. That way we can kind of move from question to question, since we do have a little bit of time left for those questions to be answered. So just to get to Judy's next question, she asks, how long did it take before the separation, etc., was completed?
For Henry and Sarah, it was about a year and a half before Henry filed for custody of his children. And then after that, it took about 6 months to have everything settled, because you still had to notify Sarah that he was going to file against her. And so time had to be given in between that. So about 2 years total.
Sharon asked, were there social implications for a divorced person? Did they differ from men and women?
So with men, they were not seen so badly upon. So Henry's business might have been affected a little bit, but it most likely wasn't. Now with women, they would get a lot of scorn and public backlash. However, sometimes they would take that to their advantage, and they would own the fact that they were divorced women. So it just depended on who they were and where they were. In a place like Marietta, where their divorce was more likely known, it would have had a bigger implication than in a place like Columbus, where not as many people would be aware of that.
Great, thank you, Madison. We do have a question from Jerry. She asks, can you talk about Henry's relationship with his sons?
So I did not focus too much on that in my presentation, but I do know a little bit about that just from prior research. So he did not beat just his daughter, Kate. He also beat one of his sons at one point. I can't remember which one. And something happened and he never touched them again. His children resented him. His son Rufus refused to talk about him after the fact. And he even called Ephraim by a different name because he hated his father-in-law so much.
Thank you, Madison. We did have a question about if this will be recorded, and it is being recorded, and we do hope to offer this on our website. I will go ahead and put the link to that portion of the website into the chat feature for everyone. And we do have another question, Madison. Scott asks, could you comment more on Henry's claim of adultery? Did he claim that his son Ephraim, born after their separation, was a product of adultery and his own personal renaming of young Ephraim?
So as far as I can tell, he did not claim that about Ephraim. The divorce accusation, it was just brought up once in trial, and that was more to say of what Henry's cruelty towards her was. I believe the case was at one point there was a handyman in their house and he was upstairs and Sarah was upstairs, and when the man came down, Henry got mad and accused her of adultery. But that's about it for that I came across.
I think another part of that question was about renaming of Ephraim.
So he did that because he hated his father-in-law so much that he didn't want his son to be named that. And so he refused to call him that.
You have another question that asks, is there any information as to how the children fared?
So 3 of the children died quite young. Sarah outlived 3 of them. And Rufus Dawes went on to become quite successful in politics in Ohio. So did her daughter, Sarah Jane. She became a mercenary. But as to the rest of them, not very much happened.
Peggy asks, from family letters and journals, it is obvious that Sarah was very religious. I've always thought that one of the reasons she didn't pursue divorce was because of her belief that marriage was forever. I guess more of a commentary.
I did not really get into too much of their own personal beliefs, but that would definitely make sense in this, and that she really had no desire to be fully divorced from her husband. She just didn't want to be with him. And that might also explain her implications of wanting to be so clear that she was not a divorced woman.
Thank you. Barb has a question, and that is, what happened at the time that Henry was dying? What did the children do?
So I believe one of his children, I think it was Kate, I think she took care of him when he was dying. I have a letter that was sent to the children after that happened, and it just said that one of them was there with him and that he kind of made peace in his older age.
Okay, thank you. I'm not seeing any more questions at the moment. We will give it a few seconds to see if there's any other questions that come in. Oh, there is one more. Great. So go ahead and keep those questions coming. We do have time to answer a few more. The question that just came in says, did Henry have any women living with him after the separation or father any other children out of his and Sarah's marriage?
I am not aware of any of that, though I did not follow him too closely after their separation. I was more focused on Sarah.
Okay. All right, and we will just give you a couple seconds to see if there are any other questions. Is there anything else you might want to elaborate on at this time, Madison, while we kind of wait to see if there's any questions?
Sure. So on my chart that I have, let me get back to it. I can talk a little bit more about the different causes of divorce here. So in this, you can see what the different kind of effects and chances are. So you can see that adultery had the highest chances of a successful divorce petition, while things like bigamy and imprisonment were much lower, but that is also because there were not as many cases of that in my sample. And then over on the sides of where you have 2 different causes together, they were all bad except for drunken left, though that did not increase your chances really hardly at all. to me, I was very surprised to see that altogether.
Great. Thank you. Another question came in, and it says, Henry didn't father any more children. That this is a response, I suppose. Henry didn't father any more children. He tried to persuade other female relatives to come keep house for him. Kate went for a while, but refused to stay, even though he bought her an accordion. Thank you, Peggy, for including that. One question asked, did Sarah do any business activities or do any public activity after the separation? Or did she live a private life?
So after the separation, the one thing that I did find is that she ran a boarding house for a little while.
Great. Okay, that seems to have come to the end of our questions. So thank you very much, Madison, for the presentation. We really do appreciate you taking the time to give this presentation for the castle. I will just mention that Madison is, we always try to feature a student from Marietta College to do the first of our Third Thursday Talk series for the year. And our Third Thursday Talk series happens on the even numbered months of the year every third Thursday. And most of our presentations and nearly all of our presentations for the first half of the year will be virtual. So you can log into those from anywhere that you are coming from. We do have one coming up in April, and we will be announcing that via our website and social media, so please stay tuned. Madison, just want to take one last time to thank you before I did our last slide here, so really appreciate you joining us. So our last slide, we just wanted to take a moment to thank you for attending the presentation. We do hope that you enjoyed it. If you do feel the obligation to, we would certainly appreciate a donation from you for this presentation. You can also become a member, and I will be putting into the chat, if I can get to our chapter here, the links to this, to these hyperlinks that we have mentioned on the screen. There's also a link in there to find out about our events that are coming up throughout the remainder of the year, which are being placed on our website in a quarterly basis. I did see one last question come in, which is for me. So our talks will remain virtual for the foreseeable future. When we are able to offer in-person programming again, of course, we will be able to have talks here at the castle. Most likely, we will still retain a virtual element. So if you are far outside of Marietta, you will still be able to attend these talks virtually, but we do hope to practice in-person programming once it is safe to do so. So thank you for that question. And thank you again, Matt, for the presentation. And thank you all for attending this program. We hope you enjoyed it, and we will see you next time, hopefully. Thank you. Bye-bye.